evening, ladies and gentlemen, boys and girls, and welcome to the August 24th edition of Beyond the Headlines. My name is Colin, Dowe, and I'll be serving as your host this evening. We begin this evening as we begin every Monday evening by saying thank you. Thank you for making this Monday evening, including us in your Monday evening. That's very important to us. So whether you're looking on GBN television, listening on GBN radio, or logged on to any of our social media platforms, welcome to Beyond the Headlines. This evening we're taking on a matter that has gotten some discussion a little bit north of us, but I don't believe it is away from us. And we're going to be having a conversation on judicial independence. And I have with me two esteemed attorneys, Lady Anande Trotman-Joseph. Welcome again to Beyond the Headlines.
Pleasure to be here as always, Colin, and of course to be with our viewers and listening public.
And Mr. Ruggers Ferguson KC. Welcome back, Ruggers.
Yes, thank you, Colin. Good evening, and good evening to all listeners and viewers.
Okay. I would just want to set the backdrop for something that occurred Antigua in recent days, last week or thereabouts, and it has made the rounds. And I will just like to give a quotation. Antiguan Prime Minister is stated during a press briefing, stating, "Brother man, if you cannot follow the lead of Parliament to give longer sentences, leave our country voluntarily. Otherwise, we are going to deport you and make you persona non grata." End of quote. Coming from Prime Minister Gaston Brong in relation to an unnamed member of the judiciary. Can you share some background as to what may have prompted a statement of this nature and what one has interpreted as a threat to a member of the bench?
Well, thanks. I'll go first on this topic. And we can only surmise, and for me, I would understand that Prime Minister Brown is understandably quite frustrated. I believe this is now his third round at leading his country, just fresh out of an election. His adrenaline would still be up, and, he still perhaps is in a little bit of campaign mode as he tries to set the new mandate for this term of his office. Now, Antigua and Barbuda, along with most of the Caribbean countries, have been dealing a lot with criminality by gangs, gun violence, gun crimes, and it has really been a concern for CARICOM as an entire region, because we all know that there is no country among this region or among us that manufactures guns. So they have to be coming from somewhere. We know that our region also has some very porous borders because of the layout of especially the Caribbean side of it, the Atlantic Ocean, and some parts of our borders. And the gun running has also been associated with the Caribbean being a major trade route for cocaine, marijuana, and more recently, fentanyl. And I'm also minded that for Prime Minister Brown having to show that he has the heft that is required to lead his country at a very difficult time in our geopolitical history for this region, because as we know, his country, like ours here in Grenada, has been affected by the U.S. Restrictions of visas for our citizens, and also the CBI programs are under challenge for some of the Eastern Caribbean territories that offer the citizenship by investment programs. So I'm sure that Prime Minister Brown felt the need to show the geopolitical powers and the gangs at home that he is very strong on crime. But having said all of that and putting it into some context, question is, did he go too far in terms of our constitutional arrangements and what we lawyers call the separation of powers? But I will stop here because I'm sure that my colleague Ruggles will come up with some more.
Additional context, Ruggles, and of course we heard the condemnations coming from the Antigua and Barbuda Bar Association, the OECS Bar Association, the Commonwealth Law Association weighed in. I think CARICOM or Caribbean Judiciary likewise weighed in. But some additional context, and what was the impetus of these law associations lending their voice to the situation?
Yes, thank you, Colin. Well, my friend and colleague has been very generous in trying to explain
Just setting up
what cannot in any way be justifiable. I mean, it was an outrageous statement. I think the Prime Minister himself must recognize it, and those around him that I know probably were petrified as others, because it's a direct attack on the judiciary. Now, one is not saying that, listen, there are problems, and this is not a Prime Minister who is new, who is coming out, as my friend said, he's unexperienced, he's into his third or fourth term in office, and therefore the language you use is important, and you quoted from the core of the statement. First of all, disrespectful. Who is referring to as brother man? You're speaking about a judicial officer, right? And again, these politicians who pander to the public. And again, you see it, because when there was an opportunity, when the powers, that the US and all these giving directives, and they're all angry. But nobody tells the Bar Association, piss off. Nobody tells the president, piss off, when probably it's justifiable to say so. But it is one in which he feels, and I'm sure that's not the case, because it cannot be for an experienced Prime Minister like that. It's listen, you comply with what we want you to comply with, or you leave voluntarily, or we deport you. Who says that? I mean, it's clearly outrageous, and we can see the damage control that came after. Isn't
that something that has been happening to the line or else? I mean, that seems to be our political environment.
Well, but I don't think our prime ministers go that far, to be fair to them. And you can't blame judicial officers for crime.
Yeah.
That these judicial officers deal with crime when they are really victims. You want to focus on not creating victims in the first place.
But that is
right?
true. But
yes.
Just share, what is the real objection as singled out by the various bar associations?
Yes.
What is the real objection?
Well, it's a threat to the independence of the judiciary as your actual theme. This is a politician speaking to a judicial officer and saying, basically, you do as we want you to do, or else we will deport you, and ended it by saying the Prime Minister of this country is saying this. I mean, who says this would go on for some time? This is a country that is hosting the Commonwealth, big Commonwealth meeting.
Right, in a couple of months.
Right?
Mm-hmm.
In a few months. And you have not just the Commonwealth Lawyers Association coming down like a ton of bricks on it. You have the Commonwealth Judges and Magistrates Association. You have the heads of judiciary of the region. You have the OECS Bar. You have OGBA. And I think that kind of reaction was not expected, and he felt probably that, listen, I could deal with them guys in the local bar, right? But when you touch these nerve subjects, You're dealing with everybody in the Commonwealth.
What would be your sign of empathy for Prime Minister Brown? And they opened up with some empathy and rationale. What would be your sign of empathy for Prime Minister Brown?
Well, you know, you're focusing on empathy. Of course, listen, crime is a reality. Crime is a reality, and again, it would breed a certain measure of frustration, how you deal with it. But not so much how you treat with criminals, but how you prevent crime. Right? That is part of the first step. What kind of programs do you have to ensure especially that our young people stay away from crime? Right? And of course, you would have criminals and criminal elements, but you know, the statement itself, you know, and with all due respect, it shows a lack of, unless it's one described as a pure ego trip, pure arrogance. So it shows a lack of understanding.
But you mentioned the preventive measures that a society ought to take to minimize, mitigate, prevent crime. Fact. But isn't sentencing, because some will still violate, isn't sentencing an integral part of the whole process?
It is.
And the frustrations that we heard from Prime Minister Brown was geared towards that. And I don't believe that the two are mutually exclusive. I'm not saying that he ignored the preventive measures, but rather what we heard was an outburst on the sentencing aspect of the whole.
If I may come in here, I have been looking of course, at this situation in Antigua and Barbuda. And based on my experience working here in Grenada, especially around the area of working with the Bar Association, but with child rights, juvenile rights, and working with vulnerable groups, I would have to say that Prime Minister Brown is transferring the problem from where it really resides. When the court deals with a sentencing issue, the buck stops at the court, but that is not where the problem begins. And we should understand from a policy point of view that each of our territories has to have its own unique crime prevention policy for its own individual country, nation, island. And I always, when I do advocacy, through the Bar Association in particular, and in my other areas of advocacy around social justice, we realize that we have to take a life cycle approach in dealing with this. You have to also make sure that there is educational approaches, interventions, starting with children at a very young age, because you can't fix it at the point of sentencing. You have to fix it right where the problem begins. You have to go into the hot spots of the island. You have to ensure that your policing, your security, your border security, there is so much involved way before we get to the courts. So to put it on Brother Man, the judge, and make him totally responsible for your porous borders that are not being properly manned, for perhaps gaps in your immigration policies and processes, gaps in your juvenile justice prevention programs, your community development programs, your safety nets, and so on and so on. I think it perhaps was not well thought out of Prime Minister Brown to say that.
Is that a fair summary? In that,
yes.
Are we saying that Prime Minister Brown ignored all of the preventive measures, all of the ills and challenges that exist in Antigua, and only focus on this? Or was this the topic of conversation on that day?
It was the topic of conversation, but what I'm saying is that in making this statement, it was an outburst, obviously, but it was not taking into account what led all the way up to sentencing. And you have to look at these things holistically. A judge can't come into your jurisdiction. He's not part of your citizens growing up and living and, you know, crime prevention and so on. And you expect with a few sentences that he will fix your entire criminal situation. It doesn't work that way. It is an holistic kind of approach to criminal justice and to crime prevention.
Brothers?
Yes, and I want to say this again. No one is free to criticize. The issue is not the criticism. It's the manner in which the criticism was done. And the total lack of respect shown for the judge and the judiciary in general. It's basically saying, listen, I'm the boss, right? You're not the boss. Because the Constitution is the boss. The Constitution is the supreme law. And it's the Constitution that defines the different roles in society. The role of the judiciary, the role of the executive, the role of the legislature. They are all co-equal arms of the state. Co-equal arms of the state. The judiciary can't tell the executive what to do, right, with its resources. That's their role. The judiciary can't pass laws. That's uniquely confined to Parliament. And just so, the judiciary interprets the law. And it is the judiciary that safeguards the Constitution and upholds the Constitution. And this is not about majority rule or majority opinion. That's not how the judiciary operates. In fact, that is why it can be a lonely and unpopular decision because, listen, remember, for ultimately a judge to rule, it must be based, first of all, on the quality of the evidence. The quality of the evidence. That's not for the judge, that's for the police and the prosecution. Right? So, first of all, is the quality of the evidence sufficient to convict, because sometimes you have people freed and so. And there'll be discussions among the public in the rum shops, on social media, this man do X and Y and Z. But it's not a court run by social media. It's a court run based on the evidence before it. And it's dependent. And that's where the judge has confined his mind to. The evidence before it. So there are lots of things to be done ancillary to all of this because in a court you have different arms. You have the judge who says what the law is in a criminal matter if there is a jury. Says what the law is. The prosecution advances the case. And the defense, the role of the defense is to ensure that the accused gets a fair trial. And of course, the role of the jury is to determine the facts in the case. And so there are different players in the system. And sometimes, okay, you might blame the police or the prosecution, but they themselves need resources. You expect them to work miracles. You expect them to solve crime. But, you know, once I went on the carnage to see detaining, and the police was saying, listen, look what we had to operate to hold up a desk on the side there. They had to jam it with all kind of books and things. They live. Some of these folks, the conditions and the facilities, you have to admire what they do. So I'm saying all of this to say that, listen, what matters in a court is the evidence in the court, not the evidence outside of the court. And that does not mean, because I would have issues with judges and judgments, but there's a route to go. You appeal. You appeal to a higher court.
Let me ask this, two things. One, because the discussion was not on the evidence. If we're talking sentencing, the person has already been found guilty. So it's the application of law is what I was hearing the criticism as being. And secondly, Prime Minister Brown is quoted as saying, criticizing the judge or judgments is not an attack on the independence of the judiciary. How would you respond to that response?
No, it is not. No, criticism. In fact, criticisms are welcome, right? And in fact, the more debate and the more issues you have, that's how society learns and grows. You have sentencing guidelines. In fact, you know, the OECS is ahead of lots of these countries because we have sentencing guidelines. And even those sentencing guidelines were made public, they're available publicly, online, And the judges, when they do like the criminal procedure guidelines and all these things, send it out. When they say nobody comments, right? So there are guidelines that the judges are bound by.
I'm going to come back to the sentencing guidelines because I want us to be able to discuss that separately. But the whole idea of the independence, would you say that our governance structure truly leads to a functional separation of powers, executive, legislative, and judiciary?
If I may, this is Constitutional Law 101. The very first subject I did when I sat in my first law class, constitutional law, taught me about the separation of powers, and that is way back in 1982. And the separation of powers is really one of the foundational legal principles of constitutional law because it has bearing on sovereignty, governance, rule of law. And it sets out, and for those who perhaps don't know what this legally separation of powers principle is about, in effect, quite simply, it sets out that there are three arms of government and each should take their own responsibility. And what has happened over the years is that through mature communications, we find that they can speak, they can be critical, they can critique, they can ask for reforms between them when they are in that kind of constructive setting. But in terms of the judiciary in particular, our own constitution makes special arrangements for, it's called, I believe in the side notes, for judicial provisions, because the judiciary has to be insulated from both the executive and the legislature.
Where I'm going is that, is that practically how it works. So I even note in the letter coming from the OECS Bar Association, there's a reference to the principle of the separation of powers. Not indicating that it is enshrined, but rather a principle of.
It's enshrined.
If it's enshrined, can you just share with us how does the Constitution speak to the separation of powers to ensure that it's enshrined? And where I'm going here as well is that if we look at the executive and the legislative, at the end of the day, all in favor say aye. And it's aye. The executive controls the legislature. Right? When we come to the appointment of judges, if you should sit, for example, on the appellate court of the OECS, I believe that you need to have a unanimous agreement among the heads of governments. And if that is true, for Chief Justice, and that in itself seems to undermine the whole principle of independence. Why should a politician, single politician, in 8 territories or 9 territories, have a say? So much so a veto vote on the appointment of a Chief Justice. So I'm asking, we say the principle, and I agree with the principle of the separation, but in practicality, is there really a separation?
Yes. Well, you want to go?
Yeah, well, yes. I would say, and that is why I spoke to the maturity of our independent systems, and that is why we have a constitution. And it clearly sets out how it is to be done, and where it is silent. Every constitution of the Eastern Caribbean the Eastern Caribbean, the OECS, Organization of Eastern Caribbean States, may vary, and ours directly speaks to the rights of the citizens in cases like sentences, but it makes specific reference to judicial provisions. It also, of course, speaks to the executive, which is the government itself, and the legislature, which is the parliament and its parliamentarians. And these constitutions have been very careful to set out the role, the functions of these different separate organs or institutions of governance, of governing our respective countries. And I think what makes things a little more complicated now, even though we know that each constitution tells us that there must be this separateness, is for the Eastern Caribbean region, we now have only one single court, the Eastern Caribbean Supreme Court. Court.
Right.
So yes, I may be Prime Minister Brown in Antigua, and I may want to speak to issues touching and concerning what is happening in terms of the justice system as it relates to my country, but the entire, by agreement and by treaties, we have agreed for this OECS region that there will be one court which is administered by a Chief Justice, and of course there is a Judicial and Legal Services Commission that assists with the hiring of judges to sit on these courts. So it is not so simple for any single Prime Minister. Yes, you have your sovereign constitution, but you also have treaty arrangements as to how your judicial system will operate. And that makes it perhaps a little more difficult in practice than perhaps a state like Trinidad and Tobago or Guyana or Jamaica or Belize or one of the standalone countries.
Okay.
So I think that's kind of where you're trying to get to, but we're going because it's not so black and white for the Eastern Caribbean Supreme Court.
Okay.
And region, sorry.
And are these appointments lifetime appointments? And where I'm going is that would an officer be insulated from influence because it's a lifetime appointment, or do you have renewals every X amount of years and therefore subjected to interference or overreach, as was threatened by Prime Minister Brown?
Oh, well, I mean, it's a threat, but it's not a threat that could be carried out. I mean, you'll have serious. I mean, he would not. It's easy to say it, whether it's in the heat of the moment. But the proper thing to have done, even though it's human to err, was to reverse. And what the bar called on him to do is to apologize. His response was piss off.
Right.
So he obviously thought it's a local bar alone that he's dealing with. And that's the importance of these various institutions that protect the independence of the judiciary. I want to go back to the point, though, that you asked about separation of powers. And as indicated, I always say, if you understand this separation of powers principle, then you understand the Constitution. It's easier for you to understand every other thing in the Constitution when you understand the separation of powers principle. You ask whether really in practice we have separation of powers. And the answer truthfully is no. Save and except in relation to the judiciary, probably, and other arms of the state. Because the executive, who is the executive essentially? Cabinet. Cabinet is the policy-making arm of the state. The parliament can't tell cabinet what to do in terms of policy. Build more roads, build an airport, build more health centers, build a hospital. That is in the province of cabinet. The court can't say anything about that because they are the policy-making arm of the state. Then now you have the parliament. And parliament consists of opposition and government. They are responsible for lawmaking. You have the lower house and the upper house. Senate, upper house, lower house, members of the House of Representatives. But there is a catch. To be a member of cabinet, you must be a member of parliament. You can't sit as a minister of government without either being an elected representative in parliament or appointed as senator. So if Colin Dowe has to be made the Minister of Education tomorrow, you will have to be appointed as senator because you're not a member of parliament. So you have, and of course, who forms the government? Who forms the government is the entity or party that has the majority in the House of Representatives. So in that way now, you can carry by simple majority. That's how most laws are passed. So even in an 8-7 instance, you can carry, you only need one vote. However, you can't engage in serious constitutional change because you need a 2/3 majority in parliament, and then we have the added element in our constitution of referenda. So you must go to a referendum and you must get 2/3 support. So, in that way, it is not pure separation. You could still have the checks and balances and opposition doing its work and so, but you mainly have, and cabinet is consensus. There's no disagreement. Cabinet takes a decision. If 4 people disagree in cabinet, we won't know, right? Because it's cabinet's decision. In parliament, you have opposition and then you'll have issues debated. And both, members of the executive and parliament, the lower house, they come through by way of elections, right? You have an elected parliament, House of Representatives, and then through that, there's a further system to select senators. So the majority in parliament would be the prime minister will come from there, and the minority, the opposition leader. Who selects the senators? Between the prime minister and the opposition leader. So with that interrelationship, you could hardly have pure separation of powers. Though, notwithstanding all of that, cabinet can't pass any law. They pilot it through parliament, and it's parliament is the institution that does it. The only entity that is not affected by an election is the judiciary. Because judges, as Lady Anande indicated, the judges are appointed by an independent Judicial and Legal Services Commission in the OECS. No politician has anything to do with the appointment of a judge. It is only the Chief Justice. And the Chief Justice, by the way, is the chairperson of the Judicial and Legal Services Commission. And we have the very unhealthy situation, I would say, in the OECS that the CCJ learned from. Because in the OECS, you must have unanimous approval of a Chief Justice. That is why everybody acting, right, for extended periods.
Right.
In CCJ, it's 75, a majority of 75%.
Okay.
So no one prime minister can hold up the appointment of a Chief Justice. Now, you make the point about, yes, somebody has to appoint the Chief Justice, and that's the heads of government. Yes, there will be a certain measure of political independence, but again, compare that to the US. People criticize our system is so far superior in that sense. In every single election in the United States of America, the composition of the United States Supreme Court comes in the fore, right? Because who, again, nominates the president? Every, not just the Chief Justice, every vacancy, it starts with a nomination by the president. And that's why you have these arguments. A man is just ready to retire, and therefore you should wait until the new government. Yes. Right? Hold on. Because it is sharply divided politically. The conservatives, and they're openly called so, conservatives and liberals, our courts are not affected by that. But we see so much outside, and we see outside as better, that all these mechanisms to protect judicial independence, we tend not to see them. And genuinely, a lot of people don't really understand the structure of our courts. But I would say, executive, legislature, fine line. Hardly any separation of powers there. But when it comes to the judiciary, it's a totally different line of appointment.
Okay.
Yeah?
Certainly, I appreciate that. Viewers and listeners, it's time for our first break. When we get back, we'll take a look at the CCJ that Ruggles mentioned a couple of times. See you shortly.
Are you longing to taste authentic, flavorful dishes from Thailand? Then look no further. Konthai, the newest restaurant located at the back of Galleria Mall top floor, is the place to satisfy your taste buds for Thai dishes that are well seasoned with fresh local spices. They offer a great selection of sumptuous dishes that will tantalize your taste buds. Visit Konthai today because the food is good, the ambiance is great, and the staff friendly. Available on Carabites and Yogo Grenada. For more information, call 456-0074 or visit konthaigrenada.com or stop by the new Galleria Mall, Grand Anse St. George. I'll meet you there. Asian Spa and Wellness Cafe, nestled in the serene surroundings of Le Phare Bleu, Calivini Bay, St. George, is the perfect spot to unwind and relax after a stressful event or when you wish to spoil yourself in the most comfortable and relaxing atmosphere. They offer many different massage modalities, including thigh hammer, washer and cupping, signature thigh deep tissue massage, also facials to depuff and tighten pores, deep cleanse full body, hair and nail treatments and more. Take a walk down to the cafe for authentic Thai breakfasts and delicious traditional dishes. Choose from our special mixed drinks, both hot and cold. Opens daily. Visit Asian Spa and Wellness Cafe today, Le Phare Bleu, Calivini Bay, St. George, because you will not regret you did. Looking to shop online from your favorite stores like Amazon and Shein? With GPC Global, it's never been easier. Get your very own US address and shop from around the world. With GPC Global, you can order the latest trends and must-have items, all delivered straight to Grenada to your closest post office for your pickup. We offer the cheapest rates and our service is reliable and quick. No more waiting for weeks for your packages. Your satisfaction is guaranteed. Join the Grenada Postal family today and start shopping smarter. Visit us online at www.grenadapostal.com or call us on 437-POST. That's 437-7678. GPC Global, your gateway to the world.
A new school year means new opportunities, but it also means new expenses. From uniforms and books to laptops, transportation and school supplies, Grenville Cooperative Credit Union Limited is here to help. Apply for a back-to-school loan and give your child the confident start they deserve with affordable financing and friendly service from the credit union you know and trust. Visit your nearest Grenville Cooperative Credit Union branch or call us today for more information. Grenville Cooperative Credit Union Limited, helping members build brighter futures, one school year at a time.
Welcome back, viewers and listeners. We're discussing judicial independence this evening with Lady Anande Trotman-Joseph and Mr. Ruggers Ferguson, KC. Ruggers, you mentioned the CCJ a couple of times and basically learning from the OACS Judicial Services. But we also saw the CCJ themselves was making news during the month of August. And there was some accusation of sentence fixing almost, because the Chief Justice being accused of assembling panels that may be favorable to a particular side. How did this come about and who raised the objections and why?
Before we get to the panels, there was a lot that came out before we got to panel fixing. Because what was shocking for us legal minds, we have spoken about Antigua, that's a challenge from without the judiciary.
Right.
But what happened at the CCJ seemed to have been a challenge that arose for that institution, that court, which is our apex court, our tip top, right up there, you know, along with the Privy Council. It's our highest court for all of our CARICOM territories in their original jurisdiction, but for some of us territories, it is our highest appellate court, whereas for some of the other CARICOM countries, they only have signed on
the treaty.
to the treaty, and that means the original jurisdiction, for example, issues such as border issues, economic issues, tariffs, and so on. But what was very shocking for those of us who, although close to carnival time, we couldn't help to really be in shock and awe when we realized that the Sunday Express in Trinidad and Tobago reported what they claimed was some leaked emails, which leaks never heard of. We haven't heard of a leak coming out of the OECS courts, for example, or any of our regional territorial courts, but a leak of emails that got into mainstream media. And it seemed initially to have started to suggest that there were some issues within the judiciary itself there around what started off quite simply as a dress code issue. And then it picked up from there, because as the leaks became more apparent and we began to read what was going on, there appeared to be dissent among the judges themselves, not only about a dress code being perhaps imposed upon them without they having been afforded the opportunity. This is just what we surmised by reading, but then it went on from there to say, well, look, there are the grouses here, we need to have meetings, because there were, as you said, now coming some kinds of discussions within that email arrangement about panel fixing. But before we get to the other issues, what was very, very concerning is that a court like that, it's one of the most technologically equipped courts in the world. Folks come from other territories, judicial folks I mean, to find out, well, how did you establish your technology and so on. But then there's a leak. Is it an intentional leak by a judge? Is it an intentional leak by supporting staff? How did this happen with an intranet system, and now everything is on the outside in your newspapers, regional to global?
Yeah, and that's certainly a challenge. So
Yes.
the bigger problem probably is the idea of the integrity of the court because of that leak.
Yes.
Brothers, anything to add on this challenge?
Yes, well, yeah, I've written about it, I've spoken about it, and to use more in positive terms. Obviously, there was correspondence, like in all institutions at different levels, that was never intended for public consumption. And that's the first thing. These are internal emails. And they are not, I don't think they go to the integrity of the court. That will obviously be a big issue in terms of public perception. Right. But I believe that all of the judges, and I can't speak too authoritatively on the more recent appointees, but they have excellent qualifications. All the members of that court experience, and I think that they're among the best that you can find, not just in the region but in the Commonwealth. Because one of the things that is not understood or known much about the CCJ, even though it's a Caribbean court, it attracts and hires people from throughout the Commonwealth.
Which was the source of the problem in terms of the dress.
Well, yes. So you'll have these problems, and I always say, listen, in every institution manned by human beings, there'll be differences. There'll be differences, whether in politics or whatever level, there'll be differences. And when you express those differences in writing, and it's meant to be internal, and that gets published, whether it's your personal life or anything, it will cause problems. But when you look at the exchanges between the judges, and it was one judge mentioned about panel fixing, right? That it could be seen because you talk that language among your peers, right? Because the judge is saying, listen, I was excluded from a panel without reason, without valid explanation, right. And therefore that could be seen as panel fixing, right? We have disagreements. So that was the judge. The president came back and said in an extensive release explaining what happened, he says, well, listen, you would not have been removed there because of any position you carry, but a refusal to comply with the dress code. And that's why I said it emerged from a dress code issue. Yes. Somebody from a different culture and so. And I'm sure there are pros and cons to the various arguments. This court is evolving. Right. And when you have the evolution and changes taking place, there'll be lots of differences.
And it was even an admittance by the Chief Justice that the regulations, there was an agreement on bench sitting, but in chambers it was silent. And right, I think this is where the
so it leaves it open, right? It leaves it open for lots of different interpretations. And as I said, it was internal correspondence, right? So certainly I'm not worried at all about the integrity of this court has established itself as an excellent court. It is named as a court of excellence internationally. 20 years of service, excellent judgments, and there is no opposition. In fact, the court has ruled against government so many times, right? The state, look at the Shanique Mairi, right. As a ruling against the state of Barbados. Barbados and Guyana were the first two countries to join the court in 2005. In fact, there was one prime minister who was out of power in Barbados. Then, probably one of the reasons he was out of power, he said, well, maybe we should remove ourselves from this court because it's always ruling against the government. So all these perceptions earlier on, I think the excellent performance of the CCJ took care of that. And it's only unfortunate that in this period, this issue could arise, whether or not it was an intentional leak. There are arguments saying it was an intentional leak. I leave these things open. I'm sure there'll be an investigation into it. But certainly, it's not like the naysayers will say, you see what I told you? Yeah. We can't run our own affairs. This in human endeavors, and that's one of the things we have to accept, criticism in every human endeavor. Scandals in the UK Supreme Court and even the US Supreme Court. But it's more managed and internal. You have one or two that escape, became little scandals, but nobody says the court is not capable.
Access to hotels and golf courses.
Well, all of these things. Yes, of course.
So I wanted to say that perhaps even though initially we were all surprised by what happened, we also have to be practical to remember that yes, it's an apex court, but it is also an organization. And from time to time, when you have challenges like these in an organization, it is also an opportunity for you to perhaps relook some of your rules, your communication systems, again, the integrity, not of the court, but of its own communication systems, its computerization, etc., etc. And I just want to say, and this is, I'm sure, speaking for both Ruggles and myself, we as advocates, especially we lawyers, we've had members of media, for especially the Jamaican Gleaner starting from as early as 1907. We've had many academics, many citizens, many representatives of organizations who believe that this court represents the pinnacle of our circle of independence. We have invested a lot in this court. We will continue to invest our advocacy, our support of this court, and we are certain that whatever has happened, this court will survive it and see it through, because there is the support, there is the expectation from those of us who have labored in the vineyard of advocacy for this court and beyond. Even, for example, somebody like our own Dr. Francis Alexis. You know, there's so many of us at every level, from the grassroots. I remember during constitutional reform, myself and Ruggles and others within our bar associations, GNOW, the Grenada National Organization for Women, and so many others, we were on the ground literally educating our public here, right here in Grenada, about the importance of the Caribbean Court of Justice. Nothing has changed.
Okay. If we are to come back to the OECS and the attack, which is where we started, is it fair for a head of government to criticize the application of the law by a judge in the public interest? And I say that in terms of the framework. We have a challenge with, in the case of Antigua, gun crime.
Yes.
We have the challenge in the case of Grenada of sexual offenses.
Yes.
And
exactly.
if the public and if a politician believes that the application of the law is too lenient, is it okay to criticize, condemn
I wanted to say,
the sentencing?
Yes. I wanted to say something because I know Ruggles will want to jump in on the sentencing guidelines perhaps. But we tend to forget that in ensuring that there is justice for the victims, that according to our own constitutions and the fundamental rights contained in those constitutions, and in particular here in Grenada, Section 3 of our constitution, I believe, speaks to the rights of persons who are, putting it in another way, in conflict with the law, who come before the courts. These folks have rights, and as part of the evolution of the common law, we know that no one is guilty, everyone is innocent, sorry, right, until proven guilty. But
the conversation is having been proven guilty.
So but I want to make that point, because people just want people to be automatically jailed without understanding, and that's why I'm bringing up the conversation about rights, that they have rights to within the system.
Right.
They may be first offenders. They're what we call sometimes in sentencing mitigating factors. So, for example, they may be young. The court will ask for a probation report about them. People from the community may have shared with the probation officer that this person may have been misled, got into this crime. So there are mitigating circumstances, especially for young people, for juveniles in particular. So yes, the crime may be serious, but in sending them to prison sometimes for extreme sentences, what happens when they come out? They become so criminalized that is a whole vicious cycle without proper rehabilitation. We think that our courts, yes, they sentence, but what happens within the jail systems of our region? Are we really effectively rehabilitating our offenders? Because there's reference in the Antigua situation here by Prime Minister Brown about repeat offenders. The problem cannot only lie with the courts. It's an entire system, and that's why I made my earlier points.
Right. Yes. And the query here is how do we juxtapose the public interest with these. So they too have rights, but the public, psychologically, socially, and in terms of physical safety, also ought to be protected.
So briefly, and that is why when we look at things from a human rights law point of view, we have a principle that emerges there that is called the balancing of rights. And that is why I tried to say that the criminals have rights, but we know that when we advocate in a criminal justice system, we usually speak for the victims and try to ensure that they get justice. So in everything, we have to balance the rights.
And I don't, you can comment on sentencing guidelines, Ruggles, but there is the person in conflict with the law, and they have rights. There's the victim for whom you'll want to get justice. And then there is probably the future victims who I think Prime Minister Brown might have been addressing, and that's the public good, the public interest that
is why I'm flagging the rehabilitation, the interventions at the community, especially that's where criminal law or criminal justice policy comes in, because the very government cannot be angry with a judge if there are gaps in effecting a criminal justice and security policy.
Ruggles, sentencing guidelines, but also just before that, do we have soft judges on the bench? Would you say that?
I wouldn't say soft judges. Judging is not an easy task because, first of all, somebody would be displeased at the end of the day. Somebody is found guilty, the judge bias. Somebody is freed, the victim is angry. Whether it's in criminal matters or so, the judge has a difficult task. And we have to understand, and the judge himself or herself is no perfect being. Right? Now, we need to give people resources to work. Right? Listen, in Grenada, right, we have, if you look at these courts, even up to now, everybody squeezes in and you can't even have a good special sitting. Now, of the court, these small courtrooms could barely hold the judges, the lawyers, and the jury, much less the public. AC breakdown for weeks. Right? People have to operate in those conditions. We have to speak about those things too. Now, the problem with the judiciary, it is not a voter-getting exercise. But if you improve the work of the judiciary, who knows about it? If you build a road, people see that. Right? So the judiciary, the judicial arm of the state, tends to be always shortchanged. And that's generally throughout the Commonwealth. Now, you see, I want to again make this point about, sustainability and developing mechanisms, common mechanisms where we can address problems as CARICOM. So we are fortunate in this region. We have not just a local court, we have an OECS court, Eastern Caribbean Supreme Court, one Chief Justice, one Court of Appeal, Judicial and Legal Services Commission. They are appointing all the judges that sit, right? We have an OECS Bar Association, we have a Caribbean Bar Association, we have CARICOM, all these structures. No. Sometimes, as I say, what the left hand is doing, the right hand doing, the right hand is no. And we tend to go over and spend monies to do all these different programs and exercises and come up with reports, things that even already done. And I don't want us end tonight without by mentioning the Needham's Point Declaration. Needham's Point, that's in Barbados, a declaration on criminal justice reform. With all, and by the way, it was facilitated by the CCJ. I always say the CCJ is not just a co-chairing matters and deciding, because you recognize there is need for criminal justice reform. That is recognized. So what happened? The CCJ brought together, facilitated a session in which you had AGs, Chief Justices, representatives of the bar, representatives of the police commissioners, representatives of the prisons, representatives of the DPP's office, representatives of the bar, to look at criminal justice reform and how we can reform the system. And they came up with a declaration called the Needham's Point Declaration that involves policy interventions, legislative interventions, beefing up the prosecution and the police, and how we can work as a unit, right, in the region. So, for example, if there's a forensic science lab in Trinidad or Jamaica, how can that lab serve the entire region, as opposed to everybody, you know, spending on a lab? And where that kind of cooperation, those are some. How do you deal with victims of crimes? Talk about the setting up of a victims compensation fund, right? The various policy interventions needed. How do we ensure greater access to justice? These are the things that, and there's an agreement. That was a resolution at the end of the day. When you hear these politicians talking,
right. I want to know how do we get to implementation, one.
But that's the point.
And two, well, is sentencing reform part of that?
Part of that, a critical part of that, in fact. One of the major issues, delays in the system. Right? Well, don't talk about places like Trinidad. You have a man on remand for 15 years, 20 years. It's shocking even to lawyers. Right? How can you have somebody on remand when even our Constitution, Section 8, speaks about any person who is charged with a criminal offense must be tried within a reasonable time by a competent court established by law. Right? Reasonable time. That's a constitutional dictate. How do we achieve that? Those are the things in Needham's Point Declaration. And I'm saying, it's not everybody going out there and blowing trumpets and trying to score cheap political points. We are committed, right? And when I say we, not just the executive, all arms of the state say, let us work towards a common goal. Because when you hear a criminal defense attorney speak about the rights of the accused, who else should he speak about? He is ensuring, defense attorneys, I always say to people, they don't go to say, you know, whatever act the person did or is alleged to have done, that is the person's right to do it. You know? That's not the role of criminal, and that's why public education is so important. You are ensuring another constitutional mandate that this person gets a fair trial in a system. So I'm saying, all of these things we have set up, and you know what's supposed to happen after that? Belize has done it well. Guyana too, because they had follow-ups. And I'm talking about even the president of Guyana, when he came, when there was a session there, as a follow-up to this, he gave the feature address and so. But none of the other islands dealing with that. You know, you treat it, some of them, you ask them what they don't even know about it. But this dealt comprehensively. Just to say, there were policy interventions. And you know what that declaration says? Listen, that crime be viewed as a public health emergency. Right? As a public health. They are agreeing with that. So it's not about one say, well, let go all the criminals, don't deal with the criminals. Everybody's saying the same thing. But it's just the method by which you approach it. And we are saying, listen, it is not the role of just one arm of the state, where you're saying the executive do this, do this, do it. Let us all work together. So they are supposed to be local committees in each jurisdiction ensuring the implementation of the Needham's Point Declaration. You know, one of the things too that people will be happy to hear, that listen, when you're dealing with you have summary matters like in the magistrate's court, these things should be within 3 to 6 months. Those should be complete. In order to complete,
who's the lead in Grenada?
Well, I can't answer you, Colin. Sorry. Right? Because Grenada does not have. There are 1 or 2 other jurisdictions, but they don't have it. I make that point. At every court session I speak in, ceremony that there is need. We have it here. We have it here. And and that's what we have been guilty of. So these concerns of Prime Minister Brown, all of these concerns have been addressed. The concerns about the judiciary and the need to build a system where there is greater access, where you deal with all these sentencing guidelines, all of these things dealt with. So it's just implementation, but everybody run off on their own thing now until we say there's a need for this, which we have already.
And you're about to start over.
That's the problem.
Let me just ask you this before we take our second break. Can sentencing decisions be appealed? So I know typically an appeal is an error in law.
Yes.
But in terms of sentencing, can there be appeal that a sentence is too lenient?
Of course there can be. And perhaps this should have also been considered, and the Prime Minister in Antigua, he should have had the advice of both perhaps his Attorney General and his DPP that this could have been done. So instead of speaking directly to a judge, there are in our constitutional arrangements, in this separation of powers environment that we ascribe to, that's what they needed to do. You're not happy about it? Appeal.
The Prime Minister don't know that. The Prime Minister knows that, right? Is who people prepared to listen to, because these folks know that you have a problem. Listen, every single judgment of a judge, a judicial officer, could be criticized by any sides, because it's an adversarial system. And that's why, in, for example, civil matters now, alternative dispute resolution is so critical. Mediation, and Grenada is big on mediation, right? Because you give the parties themselves an opportunity to settle the matter. Because when it goes to the judge, there'll be a winner and a loser. And then, even though there's a winner and a loser before the judge, there are rights of appeal, right up, in our case, to the Judicial Committee of the Privy Council. So, that is cost, that is delay, that is dragging out the matter, right? And somebody would be dissatisfied with the judge. And even though judges have difficult jobs, so that's why you appeal. You don't go publicly and attack the judge. Because again, the judge has no right of answer. It's these organizations that have to answer on behalf of the judge. What judgment you're criticizing? What are you calling soft on crime? Right? The judge is unfair because the judge cannot answer you. So when you go in that public domain, now it could be simply handled. And let me also say this to you.
And this is not something unique to Prime Minister Brown. We have had other prime ministers who have been critical of decisions.
Well, of course. So I'm saying the judge is in that unique position where all of us, at some point in time, we're dissatisfied with the decision of the judge. We don't go out and attack the judge.
Right.
All I'm saying, you're dissatisfied, you have to show example too. You don't want to create anarchy. You don't want to put the judge's life in danger. Right? You then deal with it. There are internal mechanisms to deal with that. And people might agree. You come with recommendations. And most times recommendations and all, and nobody has anything to add, and that's the sad part of it, right? Nobody even reading it. If they ain't get it, you know what? They make a whole set of noise. When they get it, they ain't reading it.
It's time for our final break, so we'll take our break, and when we come back, viewers and listeners, we want to hear from you. 440-1252, that's the number to call. We'll be back shortly.
We search for brilliance, looking far, asking wide, not realizing it's been right here all along. Makers, storytellers, dreamers shaping color, rhythm, and vision into something only Grenadians can create. But for too long, we've been working in the dark, hidden, overlooked, out of reach. Until now, Dowe's Creative Directory brings everyone, creatives, businesses, and the community into one connected space. Find the artist who understands your vision, the jeweler whose craft speaks for itself, the storyteller and musician whose work reflects who we are. Visit us at creativeaffairs.gov.gd. Your next collaboration is only one search away.
Sunrise Diagnostic Center is the place to visit for your medical laboratory test, ultrasound, X-ray, mammogram, ECG, and ultrasound guided and bone density test. Also available are COVID PCR and antigen tests. Most results are available within 24 hours. Sunrise Diagnostic Center is located at number 9 NS Building, Melville Street, St. George's, with sub-offices in Grand Anse, Wall Street, and Grenville, St. Andrew. Visit Sunrise Diagnostic Center today at any of their offices or call 440-3709 or cell phone 415-9522.
Life doesn't stand still. It moves. It grows. It asks you to believe in what's next. Your first car. Owning your home. The business you build. The future you choose to invest in. Life moves in steps. When you're ready to take the next one, we're here to help you move forward with banking solutions designed for life. From vehicle financing and mortgages to education savings, credit solutions, and support for your growing business. Republic Bank, ready for life. Every step.
Are you looking for a reliable, affordable, and customer-friendly pharmacy? Look no further than Hills and Valley Pharmacy, the nation's leading healthcare products and services provider. We are committed to serving you at convenient locations. Find an extensive and affordable selection of prescription and over-the-counter drugs and medical supplies at Church Street, Hillsborough, Carriacou, Jubilee Street, Grenville, St. Andrew, near the bus terminal, and Halifax and Grenville Street, St. George. Our committed team is always available to offer valuable assistance for managing your health and wellness. Discover the additional benefits of our wholesale distribution on Halifax Street and our Medcare Center on Grenville Street, where we provide in-house physiotherapy, massage therapy, doctor consultations, and eye care services. Our commitment is to satisfy all your healthcare needs, including competitive prices, loyalty rewards, and special discounts for seniors. Contact us at 435-6904 and WhatsApp 535-4734. Choose Hills and Valley Pharmacy. Remember, your health is our business.
Welcome back, viewers and listeners. We're having this discussion, of course, on judicial independence. Anande, we speak of the rights of the victim, we speak of the rights of the accused, and there is public interest. You know, gun violence, Antigua, gun violence, St. Lucia, certainly Trinidad and Tobago, but also sexual offenses in Grenada. I will ask my question, but let's have the listeners weigh in. Good evening, caller, welcome.
To your panel.
Yes.
My concern is that I think Grenada, the parliament went in and passed a law where if they find someone with a gun, they should get a certain amount of sentencing. And you would see the judges, they would catch somebody with a gun and they would give them plenty less. If they had to get 10, they would give them 1. And that person would come out and go and have another gun again and come back. And they will get 2 or 1.5. shouldn't the judges follow the law of the country? If the parliament put the law in place for the country, shouldn't the judges follow the law of the country? Thank you.
This actually plays right into my question. I don't believe that the sentencing or the sentencing guidelines are absolute in terms of 1 year, 2 years by and large, but there's a range. And the question is, if this is of national interest, who decides and where should there be a decision that we will go on the extreme end of the spectrum as opposed to the softer end?
I think it's a very good area, because as much as we're talking about judicial independence, we would say from a developmental point of view as well, because I spoke earlier about balancing the rights of everyone. So we can't just be weighted towards balancing the rights of the persons who commit the crimes. We have to balance the rights of our entire society, because judges cannot be tone deaf. They themselves, in many of our jurisdictions, are sometimes vulnerable and in need of protection. The police service, our Royal Grenadier Police Force, as you know, for example, would have to provide security for these judges. So they cannot afford to be tone deaf. They must understand from following what is happening. They are the ones who are pulsing what is happening in our society, because all of these crimes ultimately end up before them. So, for example, if there's a prevalence of gun crimes, yes, there are the sentencing guidelines. Yes, there must be considerations for young or juvenile offenders and so on. But if you want to stamp it out, if you want to nip crime in the bud, then there will be a need for harsher sentences which weigh the sentencing guidelines but follow the range of the law that you are speaking about. So I am saying judges should not be tone deaf. They have to remember that most of our islands are tourist destinations. For example, Grenada, Antigua, Barbados, and so on. So when citizens come here, they want to be safe. They want to know that in the event a crime is committed against them or their person, that the law will come to bear and give them the justice that they deserve. Likewise, those of us who live and work and you know, enjoy being citizens here, we want to know that the court, as much as we respect their independence of the judges, we would want to be protected by the sentencing, that it is strategic, it is responsive to the incidences of crime, the prevalence of crime, and of course we would see, even though the caller suggested that, you know, the judge might be soft on repeat offenders, I do not believe that that is the case. Sometimes the judges give some leeway for a first offender, a juvenile offender, but we will find, and my colleague Ruggles, who practices on the criminal side, will tell you that if somebody repeats and comes back, they will not receive much grace from our courts.
Ruggles, I'm hearing that they should not be tone deaf and judges should be strategic and responsive.
But it's actually part of this sentencing guidelines, the prevalence of the offense. These are all factors taken into consideration. A little more directly in relation to the caller's call, there's no issue with that. That's why judges have to follow the law. I think is the interpretation. What is the law? And that's where interpretation falls. He has given an example. Now, all these issues in terms of the, and I must say that too, these whole minimum sentences, those are right now under challenge, constitutional challenge before the court. These minimum sentences and the discretion of the court in imposing a sentence. So that is under challenge. But he's right that judges follow the law. Judicial officers have to follow the law. It is not their personal.
Why would a minimum sentence be under challenge? And I say this from the standpoint, shouldn't there be a minimal consequence for an offense?
No, because again, and let me go back to the death penalty issue, that was so obvious. in the sense, the death penalty has always been under challenge all over. And the simple principle, underline it, before the death penalty, was if you found guilty of murder, automatic death.
Right. But we have moved away from that, and that one is the ultimate. I mean, let's not go there.
Yeah, but that's the ultimate. It's the same principle.
And that one is a final ruling if we're talking death.
Yes.
But I'm just going now.
But there's a bigger
minimal sentences in jail.
Right. There's a bigger principle because you're talking about crime takes place in different circumstances, right? And that's the first principle. So there is even the sentencing guidelines. The sentencing guidelines, it does not, do not aim for a uniform sentence, as is always said. It aims for a uniform approach to sentencing. But even with that uniform approach to sentencing, you may come up with different sentences. But the variations may not be that extreme as you obtained before. But take for an example, and there are numerous examples that can be used. You walking down the road, cool, calm, never had a conviction in your life. Somebody attacks you. In the process of defending yourself, you use excessive force. That person is killed. You are charged for murder. You're convicted. Right? Ultimate sentence. Take another example. Relaxing at night at home with your family. Somebody breaks into the house, right? Robs, steals, rapes, whatever. Kills. That person is also charged for murder. The circumstances are totally different. And people understand that when, everybody who speaks, I had the example of a lady, right, who chastised me once because of a particular case I had taken up, and I was explaining to her. Within 6 weeks, that lady came to me with her son, and she called me about 10 times every day. Because her son was a good boy, did well in exams, and called me every day. Wanted me to do things that I couldn't do. Eventually the matter was resolved, and so, yeah. But that's it. When your house is, when you feeling the heat, right? As I always tease some police officers, right? When you see a police officer, they want every single constitutional right that you could think about, every challenge, and that's quite okay. But we don't understand it until we are faced with it, or somebody gets some unfair treatment. It's not, and that's why there's a system. Because look at all these things you see in the United States about how especially black people are treated. And you say, well, listen, boy, they break the law. Give them the full weight of the law. There's always another side of the story. And we must appreciate that. We must appreciate that.
But so, my query was one of minimum, because there's the other side of the story. That's why you're not on the extreme end of the spectrum.
Right.
There's minimal. Right. But for an offense, in the case if I'm walking down the road and somebody attack me, I expect to be freed. I don't expect to spend a day in jail.
No, you don't expect, but you might. A jury may not believe your story.
Well, and then,
right?
And that is the right
and
of
you
appeal.
face it.
And that's the right of
appeal. Might solve that problem. That's the problem. That's the issue.
Well,
right? But I'm saying, but I'm agreeing with you that, again, which is the answer to the question. Right. You're dissatisfied, there are levels of appeal. The state can appeal sentences.
Okay.
No, and can appeal it. So it's not a situation where you're helpless.
Right.
If you feel the judge was wrong or the magistrate, there are various mechanisms you can deal with it in an orderly way.
Let's go in just in terms of the imposition of greater consequences for running amok of the law. Prime Minister Brown, in his doubling down, speak of reintroducing hard labor. Now, is this something that we can still do? I think, I heard it. I know there's no longer that type of sentencing taking place, but he made mention of it coming out of the fallout.
You know what is interesting when I spoke earlier about human rights and so on, we in our part of the world have signed on to almost every convention and treaty to protect the rights and dignities of people. And really and truly what justice and court systems are about should be about the rights of people. And there's a lot that we have also signed on to, especially in terms of juvenile justice, the protection of persons in conflict with the law, persons imprisoned, and so on. And as time has gone on, we have agreed, for example, here in Grenada, we had a big case led by our colleague Jerry Edwin to abolish flogging. Certain things that were on our law books were seen as inhumane, and our own constitution, in our very fundamental rights provisions, tells us that we really have to consider the rights, as I said earlier, of those who are, under or in conflict with the law. There are new rights, they're evolving human rights, and there's no longer flogging, there's no longer hard labor, because we as societies felt we had evolved from that, and we have signed on to all of these international treaties and conventions.
Have we run ahead of ourselves by signing these treaties and not keeping up with the types of reform interventions that Ruggles was speaking about, whether it's pre-criminal activity or rehabilitation in the sentencing?
I believe, and again, when we look at Prime Minister Brown's outburst to a judge, that we have not kept up. I know, for example, here in Grenada, we used to have a criminal justice strategy, a whole of society strategy. I remember in the earlier days, I myself would have been part of it. We then had former Commissioner Ogilvie leading this committee and so on, and every single civil society organization and representative that you could think of would have been there. We have let such living strategies go. We are supposed to have a law revision committee in place at the national level. We are supposed to have law revision committees in place, and through those kinds of mechanisms, you test the temperature of the people on the ground. What do they want? Are our laws responsive to being harsher, less harsh on criminals, and so on and so on?
We have a caller online, so let's take that caller. Good evening, caller. Welcome.
Good evening, panel. Listen, based on what Mr. Strotman is saying, yes, the treaties that the politicians signed on to on many occasions, one, are they conditional? And two, is the judiciary consulted on the sign on to these treaties based on the fact that when you sign on to a treaty, you have to abide by the treaty, and hence the reason why those questions are being asked. So first of all, are they conditional at times? For example, if a country does not sign on to those international treaties, is it as a result they might be sanctioned or not? And then does the politician consult the judiciary before signing on to those treaties? Thank you.
Thank you.
Okay, I have to say that very often when our politicians go off and sign treaties, that there is not wide consultation. And in the case of the judiciary, they definitely would not usually be consulted unless there would have been discussions similar to what I would have shared about with respect to strategies which involve the judiciary. Sometimes they are consulted, but to be honest, in most cases, they are not. Our executive takes a decision for many reasons. Sometimes it may even be to do with funding by our World Bank or IMF, conditionalities and so on, and our grants that we receive. What also happens is, even though sometimes we commit to these treaties, we do not always pass them into law. And then what happens now is, if, for example, you'd find every now and then the United Kingdom would say, look, you've signed on to this treaty, it's not in your law. If your laws are not updated, we will not be giving you a certain kind of grant for your country. So, Paula, you are correct in asking this, because indeed and in fact, very often, neither the judiciary nor the citizens know anything about what eventually gets signed wherever, whether it's a multilateral treaty through the United Nations or a bilateral treaty about reporting on crime, for example, between, just giving an example, between Grenada and Trinidad and Tobago, for example.
Ruggles, is there a timeline for where sentencing guidelines are reviewed? Is there a caucus where the judiciary come together and say this is what is happening in our society, let us look at how we do our work? Is there a framework to address that?
Yes. And that's the opportunity to create the framework, but we don't have it. I'm saying that Needham's Point Declaration was an excellent platform to shoot off, and it's not too late. Belize, the very proactive Chief Justice, in fact, one of the senior judges of the Court of Appeal of the Eastern Caribbean, is now the Chief Justice of
we have another caller, so let's take the caller and come back to that. Good evening, caller, welcome.
Good evening, Mr. Dowe, and greetings. Just an observation to the learned Mrs. Stratman, whatever it is. Be absolutely clear with me, man. The verbal structure would have plus the past participle never tells you what happened. It does not reflect the past tense. For what it's worth, do have a nice evening, will you?
All right, thank you very much.
Citizen Rollo.
Thank you, Citizen Rollo.
Yes.
Go ahead.
Yes,
so you're talking about Belize in terms of the embrace
Belize,
of...
yes, because Belize, Chief Justice Blenman, she came out of the OECS environment and has brought many sweeping changes to the judiciary in Belize. And after that Needham's Point Declaration, a year after, Guyana hosted. And again, there were reports in terms of what they have done to implement it. The next year was Belize. But the OECS, in my view, has not grasped and embraced this in the way it needs to. Because we're talking, it's like crosstalk. You're saying we need to do this and we need to do all these things have been identified. It's a question of implementation, and it's not cast in stone. So there is flexibility, and I want to make the point. Because sometimes you see lawyer defending criminal. What our role, and I always say that. My friend is a former president of the bar. I believe in public education and information. That is what empowers the citizen to engage in informed discussion and debate. Now, this is something, and even tonight, next week I'll do this again. I did it about 5 times, right? But it's like a lone voice. I was present at this particular meeting in Barbados in October 2023. I know we didn't have any representative from Grenada, officially from the state. Right. But it is important. It's important that we take a collaborative approach, because this is not something just for the government to do. The executive, the judiciary has a role, parliament has a role, the bar associations have a role. Everybody has a role, each one of us. And therefore, it's a collaborative approach. Not attacking one another and criticizing one, not doing the other. It's easy, and especially based on our structures in the OECS and CARICOM, to get these structures going locally, to be able to address a lot of these problems. So it's not about saying, for example, that the executive criticizing the judiciary. Executive must know what are the problems and challenges facing the judiciary.
Okay.
We must all know, and it is our duty to contribute to the ongoing debate and to lessen crime.
Okay.
That's
if I'm just to ask you, because just to in your closing comments, because we're out of time.
Yeah.
So in your closing comments, if you can just speak a little bit to what are the lessons to be learned from this current debate as we move forward. I know you certainly point out that we do have a document that we ought to be working with, but what are the lessons to be learned from this current debate?
No, well, as I did a piece on the CCJ, and as a matter of fact, the sort of theme was never waste a crisis. In every crisis, an opportunity arises, and an opportunity arises for education and information and for doing something. So, for example, we had gun violence arise sometime within the last 2 years. And I made a proposal to the bar. Let's have a peace initiative. A peace initiative where, because as lawyers, you deal with a lot of these guys who come into conflict with the law. So our role shouldn't be seen as, listen, going in court and, as people say, defend criminals. We should be seen as a role of peacemakers, a role of reducing crime. What are we doing? It started off well because, and it's not the bar alone, but to mobilize other civil society organizations. And it started off well, but you need people to sustain it. I can't be involved in everything, as I always say I'm involved in too many things already, but you need that, and you need to develop that spirit where people can understand they have a contribution to make. It's not like just even appearing in court and doing a case and somebody is freed or convicted, whatever. We have a greater role as bar associations, information, education, and one of the issues, I recently had a discussion with the president of the bar, we need to revive the peace initiative. Make sure that the gang culture does not take hold. That's important. Sorry.
Ultimately, we all live here.
That's the point.
That's it.
And we all be affected by it. Right? Sorry. Yeah, so we have that role to play, and just like other citizens too. But you see, we tend to see things as everybody else's job. So we don't have a role, right? And then, so when things happen, everybody look to particular people to do something.
Right.
What are you doing about that? What are you saying about that? Not recognizing that we have that collective role to play. And that's my appeal, and to make the point that the bar are lawyers, like, who are involved in criminal practice. They're not about defending what criminals do or people are alleged to have done. Their role is to represent people who are charged with criminal offenses and ensure that they get a fair trial. Sorry, and that's a constitutional mandate that we all have to live up to.
All right. And
yes,
as always, I give the lady the last word.
Thank you very much. So this has been a very, very interesting discussion and a point of reflection for all of us. And I believe that, as you say, we all have to live here. This is a very, very small population in a very small tri-island state. And I would share, some years ago, while I was president of the Bar Association of Grenada, I had the opportunity to visit Her Majesty's prisons, as we do as a bar during Law Week, only to discover that roughly, we would say at least 80% of the persons who were there would be under the age of 25. So while we're talking about harsher sentencing, we also, because we all live here and because they will all come out, because our girls and women need to have spouses from among our population, we need to look And as Ruggles said, these persons may be our children. They may be our nephews. There are very few women who actually end up in jail here, but they may be our nieces. And therefore, more has to be done strategically, whether it is through a Needham's Point Declaration kind of approach, whether it is through social engineering, whatever we do. And I think it is time for a public conversation again. We have lots of social dialogues about how we will intervene, how we will prevent, and that has died off. Because unfortunately, as governments and civil society organizations, we are waiting for somebody to have a project and giving us money for us to speak. We have to get back to basics when we spoke among ourselves without having any money to do so. We need to look at data-driven statistics about prevalence to know how to respond to what is happening in our society. Today it might be gun violence, but yet we know what is happening in a very pervasive way year after year after year is a lot of gender-based violence, intimate partner violence, and very often when you put guns into the hands of persons who have anger issues and who are being violent within the home, then we need to be very, very concerned about our safety and security in our environment. We need to be especially focused on repeat offenders, which requires us to have and pay special attention to rehabilitation, and I would have to say monitoring once persons are released from the penal system, the jail, Her Majesty's jail. But how do you monitor them? Because they have rights. But again, if we are following through our data, through our social services system, then we would know what is happening in our society and know how to respond. We need to activate once again our law reform and law review committees through our Ministry of Legal Affairs, so that again, when we're getting this data in through our legal sector, through our social services sector, through our health sector, that we can respond. We cannot wait to say sentence young men, send them to jail, just send them all to jail, and we're not fixing the problem, because when they come back out, they will want to have that sense of power again. They will want a gun in their hand. They will want to hit someone with that gun. They will want to shoot that gun, or they will want to continue behaving the way they behaved before. So intervention, strategic intervention, and doing what we have to do as a nation.
Thank you so very much, Lady Anandi Trotman-Joseph, Sir Ruggles Ferguson Casey, for sharing on this important issue. And to you, ladies and gentlemen, for spending the last 90 plus minutes with us as we looked at judicial independence and that important arm of governance of our state. As I urge you every evening, let's take care of yourselves, let's take care of each other as we build a better Grenada. Take good care, and I look forward to being with you again in the next 6 days, 22.5 hours. Good evening all.